Welcome to the We Are Not Lawyers podcast. I'm John. No. I'm not a lawyer.
Oh, sorry, I nearly interrupted you.
You almost interrupted me.
And I'm David. Yeah.
You're David? Are you a lawyer?
No, not as far as I know.
No? He's not a lawyer either.
Can identify as one, who knows?
It depends how you wake up in the morning and how you want to identify.
According to Neil deGrasse Tyson, at least, some days, you feel like I'm 30% lawyer and then...
Do not take any of this advice as legal advice.
No.
No?
No, definitely not.
No, because, as I said earlier, we are not lawyers.
No.
So here we are again, mate, doing another podcast. If you like our podcasts, give it a thumbs up. Give us your comments on anything that we talk about. It'd be interesting to see what other people think.
Yeah, we got to get those... what was this? Oh, the thumbnails.
The thumbs?
Yeah.
Oh, the thumbnails for the video.
They're stupid.
You can follow us here.
Or whatever. I don't know.
All right, so today we're going to have a chat about IVOs, allegations.
For something new.
For something new, something that we haven't spoken about for a while.
And we can talk about fair income legal and the progression of the service.
Yes. And maybe have a chat about our case Max. We haven't spoken about that for a while. That seems to be... Should we start there, maybe?
Well, he's one of many cases.
One of many cases now, yes.
That our platform is taken care of. Max, he's had some high-level hearings.
15 in total so far?
I think it's 16.
Oh, it's 16. Okay, I must have missed one.
And would you like to know how many of those have gone in his favour?
Yes, I would.
0. Having said that, it's all a matter of perspective, of course.
It is.
The way that our doctrine is that we force the error. That's what we're doing. So a bit like the Hawks and the Blues on the weekend.
Hey, we've just timelined the video.
True.
Yeah, we have. Anyways.
So just to finish that point, so the doctrine recognises that any system, including the family law system, is entrenched if it's there long enough, operating how it operates. The courts get used to operating a certain way. The lawyers operate a certain way, and it's solid in that way. Like what to expect. Is
that what we sort of refer to as the status quo?
Yeah, I think so.
And what I also refer to as the path of least resistance.
Path of least resistance, business as usual, however you want to put it. And so, I guess those hearings where Max is not being heard or whatever the case might be, is ultimately evidence for the system's malfunction that will run across. Dozens, hundreds of cases, if not thousands, in the end. Because the popularity of our service is growing, not exponentially, but certainly rapidly.
Now, you say malfunction. The system's malfunctioned.
Well, we say that it's not. It's not in error per se. It's running as designed. But another analogy says, well, yes, but let's look at the higher level, because if a service like ours comes across to the people, which it now has, demonstrating where people are being screwed over, then you're going to start to have a population of people who grow a little bit angry, and so then we can say it's a malfunction in terms of the people. It's not delivering what the people require. And there's all of these what I would call perverse incentives that are running around. We talk about this all the time, that during separation, particularly women, although we've had some
men
that are doing this, that they take advantage of violence orders and what they provide to you as a benefit, and it's according to many lawyers, it's something that you can take advantage of during separation, and so people are doing that, and that's one of those perverse incentives, because why wouldn't the incentive to have a cohesive family unit, okay, you separate, but still, to have a cohesion, why wouldn't that be the predominant thing that you find in family law? It isn't.
No.
What you find is people being adversarial, and and it's sort of it's taking people's worst natures and really accentuating that. So that's why I say, like, yes, it's operating as designed in one way, but then in terms of like outcomes long term, as I say around the office most days, this is like the fall of Rome.
Now, I'm sort of going to take this off to a different direction a little bit. We're seeing what I classify, or what we classify, drift in the system now. And generations are now starting to see the unfairness of the system. And statistics are quite clear. A lot of men now are choosing not to actually get married anymore and not be in relationships.
Are you going towards that?
Yes, I was going to go to that.
Yeah, I'll steer it away from that.
But we are seeing a fair bit of that going on, though.
But I mean, I don't think that's any single factor, though. I think that's a lot of different factors, all just finding their home in that outcome. So, like one of the things I look at is the drop of testosterone since the 1970s. So that's certainly going to have an impact. Yeah,
the feminisation of men.
Yeah, and then we've obviously been targeted, and I mean when I say we, as in not just men, like the whole Western world and probably beyond. With ad campaigns and I mean, if you turn on the TV, which I don't, but if you did, you'd probably find ads telling you, dob your mate in. If you see him behaving,
badly.
Badly, and what is that?
Yes.
It's like the opposite of what I think badly is. Like, I think
he may have raised his voice.
He may, and I say no. Like there's a fairly high threshold to me before I would even think about reining a mate in. Like, because I think no, if you're a bloke, you've got some masculinity about you, and you don't need to answer to anyone. In a way. I mean, obviously within reason, and all the women would be like, what?
Alrighty, cool. So I took that off a little bit. Let's continue with the allegations, IVOs allegations that we were talking about earlier.
Well, so I mean, it's been I guess one of the hallmarks, I guess, of this channel, where we've talked about violence orders, and I think having looked at the Family Law Act quite intensely, and not just the Family Law Act, but actually the rules that govern it. And I mean, it's interesting to note that the rules are they're judicial legislation. Right. So that's actually where the judges come together, and they write the rules that they want people to adhere to. So things like you have to file an affidavit that's no more than 10 pages, or 20 if you're in Division 1, or the number of annexures, like when they can be served, and all of this sort of thing. And having gone through it, it is no more obvious to me than now that it is just true that violence orders are determining custody.
Right. So you talk about judges making up all these rules that are upon us to behave, I guess, in a particular way. That comes down from Parliament, from our politicians.
Well, the statute does.
Yes.
But the rules and regulations, I think, are. Actually, I'm not going to answer that because I'm not exactly sure where the regulations, where they derive from. Probably a combination. But the rules are written by judicial officers, so the judges. But the legislation is written by Parliament, or their legal.
Okay, so just sort of take it back a little fraction more. So let's just say, our politicians see a problem in society, and they all come together and decide, well, we need to do something about this problem and try and stamp it out or deal with it in some way.
Sure.
Okay, and you know, one of the key factors that's been spoken about in recent years is, you know, family violence, and you know they've introduced the AVO, the IVO, the DVO. Different states have different terminologies, as I've discovered, because I'm very new to all this, and I'm not a lawyer, and I'm learning every day.
No, and I'm not a lawyer, and yet I'm educating you.
You're educating me, yes, exactly. So anyway, so our politicians want to deal with a problem that's in society, and they then pass it on down to the judges, and then they come up with the framework, the policies,
the implementation,
and the implementation of it, which then gets passed through Parliament and
well, the rules don't. The rules are just through the judicial
process. Yeah, fantastic. Okay, and we don't advocate that there isn't any violence out there, do we? There is violence.
Oh, for sure. Like there's, I mean, this is the thing, is that we all know the statistic that there's, you know, one woman dying every few days or whatever it is, right? It's 80 odd women per year in domestic violence situations.
Yep.
It's been fairly static despite the violence orders and all the effort and energy that Parliament has put into it. Yeah.
Alrighty. So George v. Rocket.
George v. Rocket.
Let's have a quick chat about George v. Rocket.
Well, yeah, I mean, it's an interesting case. I think 1990 in the High Court of Australia. I'm not going to go into it too much.
Yeah, just touch the outside.
Touch the outside, which is it's a case about rubber stamping, and that the judiciary is not to do that. So for example, if a policeman says, John, I want to get a warrant on you and search your house for, you know, blow-up dolls of Anthony Albanese.
You had to throw that one in, didn't you?
I don't know. Look, we try to keep our personal lives separate. Okay, so all seriousness, so the police want to do a search warrant on your house because they think that you've got some contraband or whatever it is, right? You've committed a crime, they think, something like that. So they apply for a search warrant, and they take that to the court because the court must sign it off. And the thing is that in George v. Rocket, the judge, he may have been drunk. I don't know. Or maybe this was just his standard practice because...
Maybe he was partying with that blow-up doll.
Well, look, I'm not going to go there either because otherwise, look, we've already got you know, emails coming in from angry other competing bodies.
Oh yes, we do.
We're going to talk about. Look, I think it's the judge is sitting in front of a warrant, and he's like, oh well, the copper brought this in. It must be, you know, it must be
true.
Yeah. Stamp it off. See you later.
Yeah.
And in that case, the opposing party said, well, hang on, I'm not sure that that's a valid warrant because you know the grounds of it were not really indicating it was you know, really required and not lawful. And so in that case, what they ruled was something to the effect of, well, you know, the judge can't act parrot-like on the bold assertions of the police officer, and so it's a principle in law, right? That and let's bring this now back to an AVO or an IVO. And interestingly, even though they're different names, they are recognised around the Commonwealth.
Right.
So if you have an IVO in Victoria, you're still a domestic violence perpetrator according to the Commonwealth now, wherever you go. Right. So that's some good uniformity.
Yeah.
Well done on that one.
Yeah. But there's no evidence.
Well, this is the point I was going to get to, and where George v. Rocket and the other case that we've got noted up there, Briginshaw, which is more about evidentiary standards, where they come in, right? Because and why I started off by saying, these violence orders are determining custody, because the family court gets them. And they are supposed to, according to, say, a George v. Rocket type principle, look at it independently. Now, there's a few things to this. You would think, okay, let's have a look at the nature of a violence order. They're supposed to be temporary. Right? They're supposed to be temporary. They're used as a, like, we don't know what's going on here. There's been a ruckus between partners.
There's been an argument or something.
Yeah, and one's called the
police.
Police come, and they're like, well, okay, just to settle things down,
let's separate you.
Typically, it'll be the man, but it can be the woman as well. And they go, okay, just stay away from the house for a few days until this all gets sorted, right? But that's not what it is anymore. But
this is still going on in Western Australia, though. They're actually adhering to that in Western Australia, aren't they?
No.
No?
No, they do have. Like, they have a 3-day... They do have a 3-day order, but they also have a longer-term interim order, which they are relying upon as well.
Right, okay.
So it bleeds into that, just through delay, I suppose, you'd say. Like, nothing happens, and it's like, now you've got an interim order on you.
Right, okay.
And the thing is about these interim orders, a bit like COVID, where we're like, oh, we better go into lockdowns because we don't know anything about the virus. And I think at that point the Australian community said, fine, right, fine, we're not going to start protesting yet. Like, Dave O'Neill's is not going to get on his water ski just yet.
Just yet.
Right. We're going to wait. So, and it's a bit like that with the domestic... I'm trying to stop laughing internally, really, at that thought of him. Anyway, so, and if you don't know who he is...
Look him up.
I was going to say, don't bother. But in any event, no, I mean, he's a nice enough guy. But anyway, so, in fact, they're all top blokes.
Yeah,
look,
100%.
Yeah. So, these violence orders are temporary, and you look at the instrument itself, and, it doesn't require the rules of evidence to apply, and so if you look at the temporary nature, like, you can sort of go, fair enough, a bit like lockdowns. We don't need the evidence. It's just like, let's separate you two. We don't want anything untoward happening. We'll sort it out, and then you can come back to court, present your evidence, and then we'll sort it out.
Move forward.
Except they never do. They never do, and these things can last for years, for years. Like, and some people apply for these for 5 years, 10 years.
Yeah.
So on one hand, you've got an order which is seemingly for temporary purpose, without the rules of evidence applied, and then you have the family court following that through and going, well, if you have an IVO on you, then any interim orders that we make are going to be consistent with that IVO.
Yeah. So then, obviously when they start looking at child custody, they'll then take an IVO, AVO, DVO into account and say, well, hang on, you're asking for custody of your child here, but you've now been accused of committing domestic violence. And from that, well, we need to take that into consideration when we make further decisions down the track.
Yeah, they do. Even where, say you have, like one of our many clients or subscribers, however you want to frame it, who file in the family court first, and like the other party, is supposed to file within about a month in response. Even if they don't, that the court can still say, we're going to be conservative and risk averse and essentially maintain the status quo.
The status quo, yeah.
Which, if there's an IVO on you, will be that you can be completely locked out of custody.
Yeah.
So that's how that's happening.
Yeah. And look, you can sit there and argue the merits of the IVO and the claims of the IVO till you're blue in the face, and the system will just drag it to the point where you advised that you should just accept the AVO and just get on with your
consent
life and consent without admission.
Yeah,
without admission. We would advise not to do that.
Well, but that sounds like legal advice, John.
No, it's not legal advice.
Oh, we just reckon don't do that.
I just reckon don't do that.
Yeah, don't do that because, you know, if someone accuses, I mean, it's actually part of wisdom, you know, and you know, the proverb that says, "Do not own up to shit that you didn't do."
That's right. Well, you know, it's like I've always said. You know, copper pulls you over, walks to your window, and says, "You were speeding." Well, most people will just go, "Oh, yeah, I'm running late." Well. Deny everything. You admit to nothing. You know, never help a police officer in an investigation against you.
That sounds like legal advice, John.
Again.
Jeez.
No.
Look, you might have to scrub that. although, given that head, maybe it won't be taken as legal advice. No. Look at that.
No. Not legal advice. Not legal advice. Just wisdom. It's all it is. It's just wisdom.
Yeah.
And we're sharing wisdom here.
Well, you know, it's like, well, you know, you don't want to. I mean, like this sort of relates to almost, you know, every aspect of, you know, say family law that we look at. You know, like, you know, even processes like the independent children's lawyer and the family reports. You know, where we are routinely heard on the phone going, "Oh, you know, we reckon that's evidence. You know, it's just for gathering evidence." So, but of course, that's not legal advice either. So,
no, not at all. All right, let's move on to Brigginshaw.
Brigginshaw. Well,
yes.
Yeah, I mean, very related.
The two?
Yeah, very related concept because, So we found mechanisms within the we'll say the Family Law Act and rules, because it's a combination, where you can ask the court, say, okay, well, if you're going to determine custody upon my application and you don't even have the other party's submissions yet, or even if you do, okay, so we want you to list the issues that are going to determine the outcome.
Yeah.
And they must do that. It's not discretionary. And they sort of have been doing it, but behind a bit of a, you know, closed door.
Okay.
And we've discovered, okay, so you can actually make them articulate what it is that they're basing decisions on. And not just that, but then once they've listed those issues, they have to determine, are these issues for, you know, summary dismissal?
Yeah.
Right? You know, like say if I walked into the court and they said, up for discussion is, you know, is that beanie really required? Which is what you asked me when we.
Yeah, I did.
Right. And I was like, okay, well that's an issue for summary dismissal. It's not relevant in any shape or form. It doesn't pertain to anything of any substance. So they list the issues and they go, well, the beanie issue we're going to cast aside.
Yeah.
But then we're like, hang on, here's an allegation. We're going to, yes, we want to not summarily dismiss that. We're going to investigate fully. And then what does investigate fully? And this is an interesting thing because for those people who do follow family law, you might have a little bit of a panic attack like I did when I was reading this. I was like, oh no, that means that they're going to appoint the independent children's lawyer and the, you know, and we've just gone now in a full circle.
Yeah.
But no, because it's the court. The court has to determine it, not
the ICL.
No, because they're not part of the court.
No,
they are not adjudicative body.
Yep.
So it's actually a court, and so how they do that is via submission. It's also via. I do sound like a lawyer when I say things like, you know, they're going to do subpoenas under sections 67 ZB, D, and E. Right, that's the information collection architecture that they built. Updated in the whatever amendment that they made.
And that's what we were talking about earlier. That the judges put all this in play to be able to collect all this information and make a decision on it.
They do, but it hasn't been transparent, and it still isn't. And this is what we're trying to do. Because if you had parties going, oh, well, when I submit my application, I'm going to ask them to list the issues
that they've identified
that are going to be, need to be determined because it is our suspicion, without being, we're not lawyers, of course.
No.
It's our suspicion that they are building that list internally, but they're not telling us.
Now, anyone can read this information. It's publicly available, isn't it?
It is, yeah.
Yeah. So where would one go and, have a look at an archive of information or legislation?
Yeah. I mean, this takes some doing, and that's why, signing up to our service is valuable.
Well, our service is really all about educating people.
Yeah, educating, empowering, and helping manage cases through legal reasoning architecture. That's a bit of a mouthful, but anyway, they can look this up by looking at the rules themselves, the family court rules.
Yeah.
The main ones.
Yeah. Look, I've had some discussions with a few people in recent times about family law, and a lot of them are talking about AI now. AI is really assisting. But, I don't really believe that it's getting the right answers, the results that
Well, I mean, it depends what you
some
say.
are seeking.
Yeah, I mean, let's just reframe and say not the right answer, but the truth.
The truth, yeah.
Yeah, and there's this is why again our service didn't take 2 weeks to build. It's taken 2 years.
Yeah.
And that's because the Family Law Act itself is hundreds of pages. The Division 2 rules and the general rules, these are dozens of pages or hundreds of pages.
Yeah.
And to understand the architecture of how decisions are made and what the authority is of whether you're a judicial registrar, a senior judicial registrar, how the delegation works. This is all very very complex. And if you ask an AI, oh hey, I've got an IVO on me and I can't see my kids, what do I do? It'll go, oh, here, go and see Milton Lawyers, or whoever, go and see the High Conflict Divorce Centre. Go and talk to Adam, right? But it might make recommendations, but they don't necessarily talk about the outcomes that you're going to get if you just follow that.
And the doctrine of most AI these days, if you were to get the AI and type in, I've just been served an IVO here in Victoria, what do I do? In most cases, it'll probably just spit out the status quo.
I would think so. It'll probably just say, well, you need to turn up to the hearing and just consent.
Get yourself a lawyer.
Get yourself a lawyer. Consent without admissions is a good outcome, so that you can move on.
That's right. Which is the status quo.
Well,
that's pretty much what they push in the courts.
Yeah, and we've talked about this before. If you do engage a lawyer, most likely, say you've got children involved, they're going to tell you, well, for the financial reasons, we don't sort of want to go down the challenging of the violence orders because they're just going to make the order anyway.
That's right.
And we talked about why, because they're temporary orders.
That's right.
It's just that they're being used to influence custody decisions and more than that too. They're also settlements.
Settlements, yes. Yeah. Exactly. All right. Well, I'm John. I'm not a lawyer.
I'm David. I might sound like one, but I'm not.
But you're not? No. Don't take any of this as legal advice.
No.
This is just two old men and wisdom.
A little bit. And some.
A little bit. Well, I'm older than him anyways. But
yeah, that's right. Wisdom and blow-up dolls. That's what we've had today.
Oh, yeah. You love those blow-up dolls, mate, don't you?
Well.
All right. We are not lawyers. Till next time.
Cheers.